Hey my people, it is the showstopper Mr. Leopard, and I recommend that you subscribe to my YouTube channel Mr. Leopard TV, and you'll find a lot of things that I've reasoned out in the past. I've been able to discuss issues such as Jimmy Wanjigi. But in this clip, very quickly, let me give you my summarized view of the BBI petition at the Supreme Court. So I'll split it, right? I'll say that the Supreme Court is gonna give favor to BBI, so reggae shall continue. And I've been able to argue systematically that Judge Njoki Ndung'u, Smokin Wanjala, and Judge Lenaola will approve this, very obviously visible through my analysis. And Judge Oko and Judge Martha Koome are going to stop reggae. However, Judge Mwilu and Judge Ibrahim, I am stating that they will either vote in separate directions, and who is actually likely to vote against and who is likely to vote for, or that both of them will actually support the three. So it will either be 4-3, or it will be 5-2. And according to me, these matters are very straightforward. They are very straightforward to the extent that this litigation will end up with more recommendations on institutional changes and ratifications that need to be done, as opposed to the actual rulings. Of course, on a large scale, I was able to look at the judges' jurisprudence and establish whether they are, like the restrictive type or whether they are expansionists. And I've looked at their jurisprudence before, and I've established that a majority of them are expansionists in their jurisprudence. For example, if it was restrictive, then certain things that are said outrightly by Isaac Alocha, that I made these prayers at the High Court and at the Court of Appeal, but they gave me more than the prayers that I sought for. Those are technicalities that would outrightly, lead to determinations on technicalities. There are arguments by the lawyers of the president, that when the Attorney General was dismissed from representing the president at that particular time, he was not given audience at the court. He was not heard in the High Court. He was not heard at the Court of Appeal. And so the president was therefore not served, and it's a technicality. That technicality will be valid even today. So what we are seeing in court right now is a product of what Professor Mutahi Ngunyi told you before when we had the Constitutional Review Commission, the committee of experts, and Mutahi Ngunyi was calling them the committee of quacks as opposed to experts. So there are two things that they did. The first thing that they did is that they over-legislated, they over-prescribed the Constitution, to the extent that even if you were to say that the Constitution has entrenched clauses and has certain clauses that are unamendable, in the same vein, Articles 255 through to 257 over-prescribes actually on how the Constitution can be amended, and the issues that it is touching on issues such as sovereignty, like sovereignty, which is the constituent power that can be, how it can be amended. It prescribes how the supremacy of the Constitution can actually be amended. Another anomaly in the Constitution is to the extent that there are clauses that actually say that the validity and the legality of this Constitution cannot be challenged by any state organ, not even in court. They argued back, that was Oraro, they argued back to say that there are elements in the Constitution which actually make the basic structure. However, the way these elements have been prescribed, on how the Constitution amendment clauses have been prescribed, they are there. You cannot ignore them. They are in conflict with the basic structure doctrine, to the extent so much that the basic structure doctrine cannot apply, and this also stand. But my personal argument is that if you say that the basic structure doctrine is applicable, now it means that, to start with, the Constitution is too prescribed. I've already said that one blunder by the committee of experts is that they over-prescribe. So the only way you can allow the basic structure doctrine to do, yet the Constitution is supreme, then you must allow the Constitution in Articles 16 and then 255 to 257 to be amended and be written differently in order for the Constitution to be able to be amended. And so if you can allow that to be amended, then the end result of the BBI appeal is that the amendments that are sought are actually valid. So you cannot apply the basic structure doctrine, you cannot apply it and disallow amendments to those very provisions in the Constitution at the same time. The end result is the same. It's a zero-sum game. And then the popular initiative, there was the question Judge Oko asking, so when does it actually begin? And the argument was it after the signatures have been submitted or not? And the argument was excellent by Judge Elisha Ongoya. And he says that It only becomes popular when an idea has been conceptualized and initiated, and then it is subjected to the people, and a million signatures are appended. And these signatures are brought back to IEBC for verification that they are genuine and they actually signed. And the moment the IEBC confirms that a million people or more than a million people have supported it, then that initiative is popular. And if it does not meet that threshold, then it is not popular. And therefore, the popular initiative cannot be claimed to have begun in any other format and at any other stage other than after it has actually been verified and vindicated by IEBC as popular. So, the judges are the showstoppers of this case, that when they ask questions and they lead you a certain direction and ask you to explain, it means that that is what the argument is. When they ask a question, it's a reciprocal statement, and therefore that statement is what you're supposed to rebuttal to convince the judge otherwise, or then uphold that reciprocal statement. So there were arguments, for example, as to whether occasion had arisen for IEBC to make a determination on the referendum question. And it was argued, Judge Ouko spoke about it, Judge Martha Koome spoke about it, and the response, a good response, actually came from Professor Githu Muigai, who actually said that he borrows from the dissenting opinion of Judge Tuyot of the Court of Appeal, who actually said that the referendum question had not been asked, that IEBC had not been seized of the opportunity to even frame the referendum question. And so we don't know whether they would have given us one referendum question or more than one referendum question, whether there were to be many bills or whatever, but the issue of the referendum question had not arisen yet. And so it was prejudicial to actually make that particular determination. And the questioning by Judge Smokin Wanjala around that, the line of questioning is actually a reciprocal statement that almost agrees that occasion had not arisen for this to happen. The other thing about IEBC is this particular argument as to quorum. And so the good judge, not judge, but Advocate Angawa actually eloquently argues 2 points. So one, she argues that as much as the law, the constitution, puts the minimum number of commissioners at 3, the legislation also expects that IEBC should sit in quorum. And so sitting in quorum, she uses the dictionary to explain that quorum actually means that it needs to be a majoritarian status. And a majoritarian status actually means that out of the sitting number of commissioners, the quorum should be 3. That is in the legislation. So if they are 3 commissioners, minimum number, the quorum that is making those decisions is actually supposed to be a majority, which is 2 out of 3. And if it is 2 out of 3, then it is in conflict with the constitution that anticipates that the minimum number of people, in quorum. So that is the argument that she makes, that the quorum, they did not have quorum to make these kind of decisions, and quorum actually goes below the number of commissioners. So it is, again, a question of the chicken and the egg. My personal argument would be that Advocate Angawa did not convince the court that there were any decisions that were made which were not unanimous and required a vote by the commissioners in order to have, where the majority would then be 2 versus 1 and the 2. So as quorum defined, there is a conflict, and I agree with Advocate Angawa that then the Supreme Court will need to advise and give recommendation that the legislature actually goes ahead to review that particular legislation and actually establish, the issues of quorum. Now, as to whether they will say IEBC was not properly constituted, I don't know. It is neither here nor there. Then there are issues about the president. Now, you here, Judge Ndungu, ask, is the president allowed to make legislation? How does how does the executive find its legislation in parliament? Are they not proposals from the president and that kind of a thing? Well, what she is not realizing here is that the discussion here is about popular initiative, which is a different issue altogether. She asks about the president, and Jokindungu asks that, the Wanjikus, the ordinary person, when they have a popular initiative, are they prohibited in any way to seek support and to seek participation by politicians who may include the president? That is a reciprocal statement of what her personal view is about that particular matter. So it is what it is, and those are the premises that I have used to build my case to make a conclusion on what every single judge is going to rule, and therefore the total outcome of the judge. It's been the showstopper, Mr. Leopard. Please subscribe to my YouTube channel, Mr. Leopard TV. Share this information widely and let us enjoy this company. I love the support that you give me, and I appreciate you. God bless you. See you in my next clips discussing other emerging issues. Okay, ladies and gentlemen.